As typically happens in any high-profile case, the government or the prosecution always pushes the timeline and tries to make things move faster than possible. Same thing's happening in the case against Luigi Mangione, and how the government is rushing to put him to death quicker than normal. And Avi Moskowitz has filed a new document basically suggesting that the government hold their horses a little bit. Let's talk about that document now. Now, Avi Moskowitz is a specialist in the death penalty. In the case of Luigi Mangione, the alleged shooter of Brian Thompson, CEO of United Healthcare in New York City on December 4th. And keep in mind, Luigi Mangione has the presumption of innocence until proven guilty, and his defense attorney, Karen Agnifilo, who is representing him both in the state of New York and the federal government in New York, is simultaneously fighting two court cases at once and is trying to get the state to rest their case so that we can focus on the big case, which is the one that involves the death penalty. In addition, Avi Moskowitz is brought into the defense team because they're a specialist in the death penalty. In many states, the case is when death is on the line, and I'm going to avoid making a reference to The Princess Bride with the Sicilian, but anyways, when death is on the line, you need to have a specialist. I couldn't get away from it. Anyways, you have to have a specialist in the death penalty. Avi Moskowitz is that specialist in the death penalty. And so comes now Avi Moskowitz towards the court in the case of the Southern District of New York. This is the federal case against Mangione, basically arguing that they need to set a deadline and right now get them the information they need to properly prepare for a death penalty case. So the argument that we're going to look at just briefly so that you're up to date, because people have been asking me, why aren't you covering the latest court document? Well, here we go. There's not a lot to talk about it. I'm going to get there. There's a big difference, by the way, between Avi Moskowitz and Karen Agnifilo, in my opinion. Avi is more factual. Karen is more flamboyant and great with words. So she has that trial attorney kind of attack where she is very good with her words, and she'll say, Avi, for example, Avi will say, here are the facts. Karen Agnifilo might say, here are the facts, bitch. Now do something about it. That's the difference to the presentation. So both of them present facts, yes, but Karen will put a little flair on it to let you know how she really feels about it. Avi's a little bit more nuanced and a little harder to read, but I'll do my best to get into it. At argument here, we're going to go ahead and put the latest document on there for you to take a peek at. Let's switch to this. So this is the filing, the notice of motion. This is filed on behalf of Luigi Mangione. In the case of the United States of America versus Luigi Mangione, filed in the United States District Court, Southern District of New York. By the way, it's been a while for some of you. Luigi Mangione faces simultaneous counts in the state of New York and the federal government in New York. The federal government has the death penalty. The state does not. The state is trying to charge him with terrorism charges. The government is trying to charge him with charges that have aggravating circumstances that are worthy of death. And now Avi, as the death specialist, is going to tell us why those aggravating circumstances need to be articulated very, very clearly. So here's the notice. I'm going to only highlight certain sections. Like Karen Agnifilo, Avi likes to repeat things multiple times. So it's in several different sections. I'm not going to spend time because it's not as flowery as Karen's. It doesn't read as well, but that doesn't mean Avi isn't a top-notch attorney doing his job in the death penalty part of this case. So I highlighted, for example, on the screen, I'm going to try to make this a little bigger for you. I highlighted the Federal Death Penalty Act, FDPA, because that acronym will show up again. So all of this is he's addressing the Federal Death Penalty Act, FDPA, which stipulates how things work in a death penalty case now. So he says, we basically start with, hereby moves the court to direct the government to provide him with informational outline concerning the statutory and non-statutory aggravating factors that it intends to prove at a capital sentencing phase of his trial to support a death sentence. Now, one of the things I like to do is I like to run things through the universal translator, as I said. What that says in weird, plain, boring, not so flowery, Karen Agnifilo style language is, you need to provide us the actual details, the aggravating circumstances that require this to be putting somebody to death for. That's the universal translator. At such sentencing phase, aggravating factors will play a role similar to offense elements at the guilt-innocent trial. So there's a guilt phase, and then there's the sentencing phase. So again, Avi doesn't have his stuff is a little harder to read and a little harder to interpret. It's not as plain language, and so that needs a lot of universal translator, and that can be boring, so I'm going to do my best at that. But here, for most of the aggravators, so here in this case, most of the aggravators, including the critical ones involving the alleged creation of a grave risk of death to one or more persons other than the victim, the crime's effects on the deceased family and friends and coworkers, and the alleged future dangerousness of Mr. Mangione, the indictment and the government's death penalty notice contain only bare bones, vague allegations lacking any information about the facts upon which the government intends to rely. So the argument basically is he's saying, look, you need to provide reasons why you're using these language, that he's a danger to other people, that he's done untold or exceptional damage to the family. Again, let's keep in mind something right off the bat. Anytime somebody is killed, their family members are impacted. Anytime someone dies, their family members are impacted. But in a death penalty case, what they're trying to argue is that somehow the family was impacted more than every other person who gets a family member killed. And so Avi is asking, explain yourself how it is the death of Brian Thompson is more impactful to the family than any other person who gets killed, because it's understood. It is understood that when somebody gets killed, it's going to impact the family. So you can't just use that blanket thing to say, well, that's worthy of putting somebody to death because it affected the family. Well, no shit. Murder is going to affect a family. So again, you need to clarify how it is that it's better or different or more damaging than any other murder in America. And again, this is not Avi conceding that Luigi Mangione committed the murder. That's not what he's conceding. What he's saying is you're charging that my man did this, and that if he did, it was somehow more heinous than any other murder. So explain to me how that is the case, that it's more heinous than any other murder. These are the reasons why we're going to try and take death penalty off the table. You're not proving that this is anything different than the other 300 and something murders that were created, that were committed in New York last year. That was one of the things that in our flowery Karen Agnifilo language, she said, explain to me how Brian Thompson is more important than 300 and something other people who were killed in New York last year. Why is his case the only one that gets national media attention and has the mayor come perp walk the individual? Nobody else who killed anybody in New York got that kind of attention. Why this guy? So why this guy is only up for death penalty in this particular case? What is so different about Luigi Mangione, even if he was the shooter? All right. Now, it also prevents the court from carrying out its critical pretrial duty to act as a gatekeeper against the invalid factors and inadmissible evidence. I highlighted this sentence because it's a little bit weird and it's a little off and it's kind of in the middle here, but there's a large argument in the case of Luigi Mangione that there is inadmissible evidence. The gun, for example, that they believe was used in the commission of the crime was found on Luigi Mangione in Altoona, Pennsylvania, in what appears to be an illegal arrest of Luigi Mangione. In that backpack of Luigi Mangione, when they found the gun, they also found a letter that was basically a confession letter and notes in a spiral notebook about Luigi Mangione's struggle with his own health issues and the insurance industry. They called that a manifesto that Luigi intended to put out there to the public. That was not the case according to the attorneys. What was in that backpack were personal notes and not intended for the public. And so therefore saying it's a manifesto and that he intended to make some big political statement is a stretch. Now, in a way, it almost sounds like his lawyers are all conceding that he did indeed write those things about the health insurance industry. And so you almost get the idea that they're conceding that he's the shooter, but they're not. They are still making the case, the government prove their case in this case. And the problem is that if that arrest was illegal, and I have many videos telling you why it 100% was illegal, and I have many videos showing how Thomas Dickey, who's his attorney in Pennsylvania where Luigi Mangione was arrested, had said that was illegal, and he outlined exactly why it was illegal. And I broke down the law and told you exactly why it was illegal. And Karen Agnifilo said it from New York, by the way, that arrest in Pennsylvania is illegal, and laid out all the same things I talked about. Again, why it was illegal. It was an illegal arrest. And yet the government is pressing forward with death penalty in large part based on the information that was obtained on the arrest in Pennsylvania, which entirely may be illegal, and all of that shit may be inadmissible in court. Holy shit. I just spent all that time talking about this one sentence. Anyways, I'm trying to get everybody up to speed if it's been a while for you on this case. And if you need more education, please look at my Luigi Mangione playlist on my channel, and you'll get all up to speed on all those documents, all those arguments, why the arrest was illegal, why you would defend somebody who shot Brian Thompson if he did, because again, it's allegedly. You'll get all of that if you go back in time and watch my series. I think you'll find it very, very educational. And I have attorneys on regularly who talk about this case. So it comes with creds. So pay attention. Anyway, let's go on. I'm going too long. An informational outline should be provided. This is Avi's basically request. That ultimately this sentence is the whole purpose of this document. An informational outline should be provided within 90 days, no later than October 24th, 2025. By that date, the government will have had more than 10 months to investigate and prepare its case, and surely will be able to share with the court and the defense essential facts underlying its aggravating factors. You must understand, we've talked about this with Ali Benevento, my attorney friend, on my show in the episode called Death is Different. It's a live. You can look for that if you want on my lives on my YouTube channel, and look for the one that says Death is Different. We talk about things like this, which is that in death cases, the defense right away has to start preparing for those aggravating circumstances. What makes this crime worthy of death and not just life imprisonment as many other people would get? What makes this one special? Because death is different, and your requirements to put somebody to death are much higher than just putting somebody away in life in prison without the possibility of parole. So anyways, moreover, since the court has expressed its intention to try this case in 2026. They're pressing the timeline, as often is the case in high-profile cases. They want to rush, and they don't want to do the due process and do it the right way. So he's arguing, you're pressing fast. You've already had 10 months. You're pressing fast for a trial in 2026, and you've already had 10 months. Where is the aggravating circumstances, the facts behind the aggravating circumstances that prove Luigi Mangione's only option in this case is to be put to death? Explain this to us. You've had plenty of time, and you should normally have this done already, and you're pushing for a fast trial without completing the due process. That's what the argument is. Holy shit. Am I making this clear? Like, I feel like I'm even confusing you. Anyways, the need for sufficient time to conduct such an investigation is particularly acute in this case because the government announced its intention to seek the death penalty even before the defense had an opportunity to conduct a mitigating investigation and make a detailed factual mitigation presentation to the Department of Justice. Now, let me run that through the universal translator. Typically, from what I understand, when you're going to put somebody to death, or when you think you're going to put somebody to death, you kind of announce that you're going to think about that, and then the defense will work on an argument for the court on why it's not appropriate to actually apply the death sentence. And so normally this would be something the defense has already been on. Oh, you're thinking about putting him to death? Your Honor, here's reasons why we shouldn't even talk about charging him with the death penalty. But what happened in this case is the government went and didn't include any information and just said, by the way, we're charging him with death and we're going to put that motherfucker to death. And so that was their response. And then the defense was like, you know, what happened to the due process? We normally have an opportunity to tell the judge why this is not appropriate. Now you've told us you already are going to execute the guy, or you intend to, before we've even had our say. So now that that's done, let us have our damn say. And by the way, explain to us why death penalty is the only necessary option in the case of Luigi Mangione. What makes this man so fucking dangerous that you think he needs to be killed? So I'm getting hot because Avi's not hot enough. I'm getting hot for him. All right. On April 1st, 2025, Attorney General Pam Bondi, oh shit, if you didn't see that, that was a shitstorm. By the way, that almost got me kicked off of TikTok entirely, and I haven't been on TikTok much at all because I'm getting tired of fighting TikTok. Just mentioning Pam Bondi and what she did and what Karen Agnifilo, the attorney for Luigi Mangione's response was to Pam Bondi, that got me in trouble. I got community guidelines violation for repeating the words that Karen Agnifilo said in response to Pam Bondi. Who is Pam Bondi? She's the U.S. Attorney General who went on public TV and said, if anybody deserves to be killed for a crime, it's Luigi Mangione. This man killed an innocent man and father of two, and he needs to be executed because this man is the poster child for the death penalty. That's basically what she said. And Karen Agnifilo shot back and said, how freaking dare the U.S. attorney come on there and not presume that this person's innocent until proven guilty, and tells America he's already a murderer and that he needs to be put to death before this trial even starts and before we've even had a chance to present why the death penalty is not appropriate. And I got in trouble for mentioning that. All right. On April 1st, 2025, Attorney General Pam Bondi directed the U.S. Attorney for the Southern District of New York to seek the death penalty against Mangione. So let me explain how that works. The Southern District of New York falls under Pam Bondi's direction. She basically said, hey, Donald Trump has ordered me to be tough on crime, and so therefore I, as the U.S. Attorney General, order the Southern District of New York in this case against Luigi Mangione to seek the death penalty. That's what she did. I order you to seek the death penalty because it was possible the Southern District of New York wasn't going to seek the death penalty. In fact, early indications are very, very much so that Karen Agnifilo was told behind closed doors that they didn't intend to seek the death penalty until Pam Bondi, U.S. Attorney General, went on national TV and said the Southern District of New York will seek the death penalty in this case and demanded it. And Karen Agnifilo blew a fuse and said, that's not what the Southern District of New York said they were going to do. It's not what I was told they were going to do. We were putting this on the side thinking the death penalty was off the table. And now Pam Bondi comes out and says, no, you will seek the death penalty. And they did. And they were shitty about the way they did it. They told Karen Agnifilo, hey, relax. We haven't done it yet. We're not following Pam Bondi's orders yet. So just relax. Quit filing papers talking about how upset you are. We haven't even agreed that we're going to do that. And then they came out and said, we are officially doing that. We're gonna charge him with murder. And she's even more pissed. You told me to hold on. You told me to wait because you're not going to necessarily respond to Pam Bondi, and you did. So everything about this case has been shitty. Forget the idea that there's any handshakes behind closed doors like, hey, don't worry about it. We're not going to go for the death penalty in the case. They lied about all that shit, and it's okay. It's not illegal for them to lie, but it was clear, in my opinion, that backdoor agreements were made that they weren't going to go for the death penalty until Pam Bondi stuck her face in this and told them that they must execute Luigi Mangione. So a capital indictment was returned against Mangione on April 17th. So Pam Bondi made the statement, you need to execute him in New York. On the 17th, they formally filed the charges of death penalty notice on April 17th, and the government filed its notice on the 24th. The government filed its notice of intent to seek the death penalty on April 24th, alleging two statutory aggravating factors. Substantial planning and premeditation was one of the big things. They said the reason why we're seeking the death penalty against Luigi Mangione is there's substantial planning and premeditation. And second reason, there's a grave risk of death to additional persons. This one, I have to tell you right there, is the one that's the hardest part for them. I don't see how you say there's a risk to other persons, and that's what Avi is going to say, is how the F is Luigi Mangione, even if he was the shooter, let's keep that in mind, even if he was the shooter, how is he a grave risk to anybody else? Show me whose life's in danger because Luigi Mangione is locked up in prison. Who else is in danger for this kind of situation? And tell me who else he was going to go for. What other names did Luigi Mangione allegedly have in his list that it was his next target? None. There's nothing like that. So what exactly do you think he was in danger of doing? Now, the part about the whole premeditation and planning, Avi's going to argue that they haven't proven that as well. I think that I don't know what the rule is in law on how long you have to plan it, but obviously if Luigi Mangione did do it and he traveled across state lines to go shoot him, there's some planning and premeditation in that. So it seems like that would be a little harder sell, but essentially Avi is saying you haven't even really outlined and articulated how you think he so planned this out and planned to do a premeditated murder. So anyways, and then we're talking about three non-statutory aggravating factors as well. The victim impact, selection of the site for the act of violence, and the future dangerousness of this individual. Both the indictments and the notice of intent are bare bones and do not provide details regarding the facts the government intends to prove at the penalty phase with respect to charged aggravating factors. So again, there's two phases to trials. There's the guilt phase where you determine whether or not they're guilty, and then there's a second phase, which is the penalty phase. Now that we have determined that they're guilty, what is the penalty? So even though it seems like we're getting ahead of ourselves, when death is on the line, never get into an argument with a Sicilian when death is on the line. Anyways, when death is on, I can't do it. I love the phrase when death, I love Princess Bride. Anyways, the point being is when death is on the line, sometimes you get ahead of yourself. You need to get ahead of yourself. You need to start preparing now. As soon as they tell you that they're going to try to execute your person, you need to start working right now on why executing a person is not the appropriate intent for the future of that becoming a guilty verdict. So they start planning now, and that's a precedent in the court system. You start planning now. If you're going to tell me that you're going to try to execute this person, we will start looking right now about why death is not the ultimate option in case this person is found guilty, so that we're more than prepared to argue why death is not the appropriate sentence. All right. The allegations in the notice of intent filed in the case are generalized and unbounded, leaving the defense blind as to what acts, events, harm, or in short, what facts the government intends to prove. So that's what he's saying, is that you need there. He's asking, because it's really an ask. It's not a demand. You can't demand. Avi can't demand shit. What he's asking the court is, please, judge, demand, if you will, of the prosecution. So we are asking you to put a deadline out there for the prosecution to tell us exactly how Luigi Mangione is the worst murderer in this country and needs to be put to death, and put it in very, very blunt terms so we know exactly what your case is. Not just vague terms. Oh yeah, he was a danger to somebody. Who? He hurt some people's families. How? Like, be specific and do it in 90 days. All right. For the first of those factors, the grave risk of death to additional purpose, the notice does not identify what other persons are put in grave risk of death, nor does it provide any details as to what conduct by the defendant allegedly placed such individuals at a grave risk of death. The notice equally is silent with respect to the facts the government intends to prove regarding the impact that Mr. Thompson's death has had on his family, friends, and coworkers, saying only that the government will prove the victim's personal characteristics and the impact of the victim's death upon his family, friends, and coworkers. The notice does not specify what personal characteristics the government intends to prove, which family members or friends or coworkers were impacted by his death, and how they were impacted. Now, again, at the heart, he'll make the argument coming up that everyone who has somebody murdered in their family, everyone who loses a family member, whether it's murder or a car accident, is impacted. But So we can't just say that because family members are impacted by the death of a man, that means it's worthy of death. How is it more impactful? That's the argument. How is it more impactful than anybody else that was shot and killed? Any of the other 300 and something people that were killed in New York, how is this more impactful to his family than anyone else? And it can't be, by the way, because he's a CEO and makes a lot of money. That can't be the aggravating factor. Or if it is, put it in fucking writing, because we'll tear that shit up in court. All right. Finally, with respect to the non-statutory aggravating factor of future dangerousness, the notice simply alleges that Mr. Mangione expressed intent to target an entire industry and rally political and social opposition to that industry by engaging in an act of lethal violence. It further alleges that he sought to evade capture by law enforcement and traveled across state lines with privately manufactured gun and silencer. The notice, which, by the way, all of that may not come into court. It may be completely inadmissible, because that arrest in Altoona, Pennsylvania, I'm telling you right now, and so are all of his attorneys, was a 100% illegal arrest. And will a judge have the balls? Actually, I think it's a female in Pennsylvania. The Commonwealth of Pennsylvania is Margaret Garnett, I believe. So I guess she won't have the balls to say something. But will she have the nerve to weigh inside of the law, which is that was an illegal arrest? It was an illegal detention. It was an illegal search and seizure of his property. All of that was illegal. And I break it down in reason. Sal, will Margaret Garnett have the nerve, not the balls, the nerve to do the right thing when it comes to the law? Or is the pressure of a high-profile case so important that she will rule in favor of violating the law, which that was a violation of Luigi Mangione's constitutional rights? And I realize that at some level, I'm digressing. At some level, some of you are thinking, well, if he shot and killed somebody, who gives a shit about his constitutional rights? Well, I do, because my channel is about defending people's constitutional rights. And even somebody who commits murder has constitutional rights until proven guilty in a court of law, and we strip them of some of their constitutional rights. So we will give Mr. Mangione the presumption of innocence until proven guilty, and we will defend his constitutional rights, especially because if they're wrong and the government's wrong about it, then what they do to somebody by stripping your rights before you've had your due process should be scary as shit to everyone in America. And again, I point out, I've been this before, if this is what they'll do to somebody in a high-profile case where the entire nation is watching, what will they do to the little guy who can't afford a Karen Agnifilo as your lawyer and doesn't have all eyes on the nation, like me, asking questions? Hey, are you fucking violating our constitutional rights? If you don't have somebody like that paying attention to your case, you're just going away and nobody will know. Now, the notice does not provide any detail as to when and how he expressed an intent to target an entire industry, or in what way he intended to target the industry, other than rallying political and social opposition to the industry, or how any potential political and social opposition to the industry posed a risk of future dangerousness. The notice certainly does not contain any factual statements as to how the government intends to prove that Mr. Mangione is a future danger to anyone. So again, Avi's just simply asking is, please articulate in writing how it is you know Luigi Mangione was a future danger to anyone. Explain that to us, because because we have to prepare for that in trial. So you need to tell us exactly what it is that made him so specially dangerous to other people, so we can go, oh, that's what you're saying? Well, here's why you're wrong. But if we don't know what you're saying, we're sideblinded at court. All right. At the initial arraignment and pretrial conference held on April 25th, 2025, the court stated that it intends to set a firm trial date in 2026 at the next scheduled conference on December 5th, 2025. Let me make sure you understand what that means. The next court date in the federal government case, the Southern District of New York, is December 5th, in which they intend to, it's been stated, on December 5th of this year, they intend to set the date to start trial in 2026. That's what he's basically saying. We are going to trial in 2026 because you've indicated that December 5th is the date that we will set the trial date to happen in 2026. A 2026 trial date would require that this case move exceptionally quick, Avi says, especially considering that capital cases, on average, do not proceed to trial until at least 42 months after indictment. So what he's saying is we're moving too fast, right? Because 42 months, well, let's see, 12 and 12, that's 2 years, that's 24 months, the 36, that's 3 years. So it's over 3.5 years, over 3.5 years that a typical case would go to trial for murder, and yet we're going to try and do it in a year. So what the fuck, people? Why are we so fast to want to kill Luigi Mangione in this case? What is so special? That's the ultimate question. That is the ultimate question. What is it that if you kill a CEO in the United States, we need to rush to kill you, to make an example out of you? That's exactly what's happening in this case. This is why it's a constitutional issue for me, and why it's raising the hairs on my back of my neck, because we are rushing to execute somebody because we think somehow a CEO of a health insurance company is more important than everybody else. Everybody else in the country can just wait fucking 3 years to get their trial seen. But Luigi Mangione, you killed a CEO, somebody who makes a lot of money. That guy needs to be put to death immediately. That's wrong. We should not put somebody on a pedestal and say their life is more important than somebody else. Our legal system is designed on the principle that nobody is more important than somebody else, and yet that's how they're treating it. That somehow Brian Thompson is special, and therefore Mangione needs to be put to death immediately to make an example that you don't do that to special people. All right. The sentencing phase of a capital trial parallels an ordinary criminal trial in certain respects, with aggravating factors functioning much like elements of the offense. The government must prove each aggravating factor beyond a reasonable doubt. Jurors may not consider an aggravating factor unless they unanimously find it so proved, and their ultimate verdict turns on their findings of such factors, along with the defendant's mitigating factors, which are analogous to affirmative defenses. Now, again, that is Avi Moskowitz not being as flowery as Karen Agnifilo. I'll guarantee you, if Karen Agnifilo wrote that sentence or that paragraph, you wouldn't have any fucking question, and you wouldn't need a universal translator to tell you what she meant, because she would make it plain as day. Avi's a little bit more, I don't want to say articulate, but a bit more factual, a little bit less argumentative, if you will. So basically, they're just saying, if you're going to go to trial, the jury has to have all the factors. We have to have all the factors to make sure that they're making an informed decision of putting somebody to death, and we're not doing that in that case. That's the simple way of trying to say what he's saying. Like every defendant, Luigi Mangione is entitled to a meaningful notice of what the government intends to prove. Everyone else has to be told what you're going to try to prove against our client. Why don't you tell us about Luigi Mangione? What is so special about Luigi Mangione that you have to hide shit? You have to obfuscate stuff. I guess that's the same thing as hide shit. I say things redundantly sometimes. Point being, what makes Luigi Mangione so special that he's treated differently than everybody else? And so he needs to be able to prepare and present a defense, including any legal and evidentiary challenges. So they need to have time. Is what he's saying. So get it on the table and get it in writing and get it now, especially since you want to go execute him next year, or you want to have a trial to execute him next year. While the statute does not specify the kind or extent of the notice required, as another district court in this circuit recognized, so district courts in that circuit of courts have recognized, at a minimum, due process requires a defendant to receive sufficient notice of the aggravating factors to enable him to respond and prepare his case in rebuttal. So again, what they're stating is, when you intend to execute someone, early on, you must give them all of the sufficient notice of the aggravating factors that make death the only option, so that they have time to prepare a rebuttal when it comes time for the sentencing phase. Are you following this? So it is already understood and upheld by courts in the circuit that, yes, now, before we start the trial, is the time for us to start preparing for the rebuttal against the death sentence. Now, not later. So if you've already announced you're going to kill him, or you intend to, so now we should be preparing his defense immediately. Otherwise, it raises the specter of unfair surprise and potentially prejudices the defendant's ability to defend against the government's efforts to impose the death penalty. Again, time is of the essence. Don't wait until the penalty phase to say, oh, by the way, and here's the reason why he should be put to death. We should have known about that from the very, very beginning and had time so that we know how to explain to the jury adequately why death is not the option. You want to rush it. You want the jury to make a rash decision to kill him because you want the rash decision to kill him. All right, based on these, now we're going to get into a little bit further of the argument. Point B, based on these the due process considerations, the FDPA, that's basically the guidelines over death penalty, Based on the due process considerations, the FDPA notice requirement, and inherent judiciary authority, most district courts have agreed to order the government to produce in advance an informal outline of what specifically it intends to prove at a capital sentencing hearing for at least aggravating factors. That appears to include every district court in this circuit to address the issue. And he lists a whole bunch of courts. So basically saying every other court in this district that you're in this circuit, every other court in this circuit has agreed that you need to provide us details about what the aggravating circumstances are before trial begins, and you haven't done so. It also includes numerous district courts in other circuits across the country. So it's not just this circuit, but all over the country, it's understood that you need to provide that information. And so why haven't you done so? As discussed in greater detail below, at least 3 of the 5 aggravating factors in the government's death penalty notice: 1, grave risk of death to additional persons; 2, victim impact; and 3, future dangerousness, require an informational outline in order to provide the defense with adequate notice of the theories and facts the government intends to prove. Again, tell us how he meets any of those definitions so that we can start preparing properly. So then he breaks down in detail. Now, this is going much longer than I expected. I thought I would do this entire thing in 30 minutes, and I'm at 30 minutes now. However, I am over halfway done, so let's continue on. It's been a while since I talked to Luigi Mangione, so I'm kind of excited to get to talk about it. All right, here we go. Grave risk of death. That's one of the things that they need to prove. He's going to explain to them what they need to prove. All right. The government's death penalty notice alleges that, quote, in the commission of the offense, unquote, Luigi Mangione, quote, knowingly created a grave risk of death to 1 or more persons in addition to the victim of the offense, unquote. Now, if you will note, Karen Agnifilo has already come out and said, look, the shooter, not Luigi Mangione, the shooter appeared to have picked a time when there was hardly anybody on the street. 1 person was targeted. Steps were taken to make sure that only 1 person was hit and no innocent bystander. So what exactly is the threat to everyone else on the public when this person, the shooter, took steps to make sure only 1 person was hit and only 1 person died? Where is the threat to future people? All right, so this simply repeats, and he quotes a legal document, I think. This simply repeats the language of the aggravating factor listed in the FDPA. It provides no notice of which persons are covered, nor does the aggravating factor, as alleged, identify which acts or acts by Mr. Mangione knowingly created a grave risk to such individuals. Indeed, given that the shooting of Mr. Thompson was done on at close range, in the early morning when the street was nearly empty, it is hard to imagine, without any further specificity, how the government intends to prove this aggravating factor. So same thing Karen said. This was done early morning hours, not a lot of people around, on a relatively empty street, at close range. There was virtually no risk to the public. How is it that he's a danger to the public? The government's, and so now we're going to go into that substantial planning and premeditation part. Now, to be fair, of all of Avi Moskowitz's argument, I think this one is the weakest, because I think there is, I don't know how you get around, there's some premeditation to the murder. So I don't know how he gets around with it. But and keep in mind, Avi is gonna argue every single point and make them prove the point. So even if Avi Moskowitz was like me, like I can't, there's no way I'm gonna get away with this one. He's still gonna ask. That's his job. He's gonna prove to me how it was premeditated. Now, again, he may expect to lose that one, in my opinion, but he's gonna ask. That's his job. All right. The government's death penalty notice alleges that Mr. Mangione committed the offense after substantial planning and premeditation to cause the death of a person. The notice is devoid of any of the facts the government intends to prove to establish such planning and premeditation, including, most importantly, what acts by Mr. Mangione constituted the planning, when and where were the acts did those acts occur, and which person's death was planned and premeditated. So they're basically saying, show me where Luigi Mangione picked Brian Thompson as his target. That's one way of saying it. Show me where Luigi Mangione picked Brian Thompson as his target. Because I bet you, Avi already knows, there's nothing in writing anywhere, including on Luigi Mangione's personal notes anywhere, that Brian Thompson was the target in particular. So show me where Brian Thompson was singled out. Where's the premeditation that Brian Thompson was going to be the person shot? That's kind of where I think he's going with that. Again, in similar circumstances, other courts have ordered the government to furnish an informational outline setting forth at least the factual basis for this aggravator. So every other court wants you to lay out how it is that it was premeditated. Do the same in this case. End of story. Now we're going to get into the victim impact. Same thing I told you already. everybody who dies is going to have impact on the family. How is Luigi Mangione's alleged act different than everybody else? How did it impact the family worse than anyone else the other 300 and something people in New York that lost people due to murder last year? All right. In its death penalty notice, the government alleges a broad-ranging, non-statutory aggravating factor, victim impact, involving the life of the victim and the crime's effects on his family, friends, and coworkers. Okay, again, every time someone dies, it's going to affect your friends and your family and coworkers. Yet, we don't seek the death penalty in every single murder case. So, if you're going to say, we're going to seek the death penalty because you affected his family and friends, and every single murder affects family and friends, how is it different that this warrants murder and not everybody else's case? For this, the notice says only that the government will prove that the injury, harm, and loss caused by Luigi Mangione to the family and friends and coworkers of Brian Thompson, as, quote, evidenced by the victim's personal characteristics and by the impact of the victim's death upon his family, friends, and coworkers. So the notice is silent on what characteristics of Mr. Thompson the government intends to prove, which family members, friends, or coworkers were impacted by his loss, and the nature of the impact suffered by each relative, friend, or coworker that the government intends to rely on. Now, he doesn't mean specifically explain to us how they were impacted. Everybody knows they were impacted. Anybody who lost somebody that's close to them is going to be impacted. That's not what he's saying. What he's saying is show us how it is different or more substantial than anybody else in America. As other district courts, including this circuit, have recognized, that range of human suffering, whether physical, emotional, or economic, is vast, goes beyond saying. Basically, everyone has this reaction to death and murder. It's like that's what happens when people die. It affects people around them. Thus, an oblique reference to victims, injury, harm, and loss, without more, does nothing to guide the defendant's vital task of preparing for the penalty phase of the trial. So again, tell us how it's different, specifically, so we can address that. As the district judge who handled the first mass killing case tried under the FDPA under the first case tried, let me read that a little bit better. As the district judge who handled the first mass killing case tried under the FDPA, so they're basically, the FDPA was a set of guidelines on how to do death penalty. The first case that fell under those new guidelines, it says, as the district judge noted in that first case that was using these guidelines, said, this is the most problematic of all the aggravating factors and may present the greatest difficulty in determining the nature and scope of information to be considered. What does that mean? Break that through the universal translator. That means when they made the guidelines that we're following, that this particular rule about proving victim impact was going to be the hardest to prove in court. How do you prove that the victim impact was worse in this case than anyone else? That's my universal translation. Even the first case that came up, the judge said, this is going to be the hardest one, victim impact, how to rule. How do we prove that somebody was more impacted than anybody else in America? All right. Thus, faced with similarly conclusory notices for victim impact, courts in other cases have ordered the government to more specifically articulate the nature of this aggravator. In other words, everyone is impacted by death, and so courts have understood that this statement in the FDPA about victim impact needs to be clarified. More specifically, you must articulate the nature of the aggravator. One court directed, I realize this is legalese, and you're like, oh my God, like I'm confused. It's legalese. We'll get attorneys on if you need. We'll break this down and talk about it a little bit better. One court directed the government to specify which members of the victim's family have suffered, the nature of their suffering, the nature of their permanent harm. For example, whether members of their family sought counseling or other medical treatment, such as hospitalization. So, in other words, get us the specifics. This was so horrendous that other people who lost family members didn't have to go get mental help and put into a psych ward or whatever the case may be. Show me something like that. That's the kind of thing you need to show. How was Brian Thompson's family affected more than anyone else? Compared to other people that have suffered loss, show me something that shows that his family suffered more loss than the average person. That's how that universal translation is being made by me. I could be wrong, but it could be. Most recently, Gendrum Court finding that, quote, an informational outline is necessary to give notice of the extent and scope of injuries and the loss of government that the government alleges, unquote, ordered the government to, quote, provide an outline with the personal characteristics it intends to prove as to each victim, the identities of the people whom it intends to prove were affected, and the type and scope of loss, injury, and harm suffered. So in other words, they're saying, you can't just generally say his family was impacted. You must tell me his wife was impacted, his child whatever the child's name is was impacted, and it was because they then had to go and get extra counseling and couldn't go through school anymore. They couldn't focus on their grades, whatever the case may be. You need to outline specifically who was impacted and in what way. You can't just generally say, oh, his friends and family were impacted. Well, fucking no shit. Everyone who suffers murder is going to have friends and family impacted. Tell me exactly what happened to this family specifically that made it worse than anyone else in America that's been beaten to death. And then the future dangerousness argument. We're almost done with this document, people. I never thought it would take me almost an hour to do. We're almost done. The final non-statutory aggravator crafted by the government for its death penalty notice is the future dangerousness. The notice is vague and unspecific about this, saying only that Luigi Mangione presented a future danger because he, quote, expressed intent to target an entire industry and rally political and social opposition to that industry by engaging in an act of lethal violence, and he took steps to evade law enforcement, flee New York City immediately after the murder, and cross state lines while armed with a privately manufactured firearm and silencer, unquote. That's a long fucking sentence, and it includes a lot in it. Basically, what he's trying to say is Luigi Mangione was going to try to use this to incite social violence against the industry by others to follow his example, I think is what they're trying to say. The notice does not explain in what way Mr. Mangione intended to target an entire industry. Does the government intend to prove that he intended to kill other people in the health insurance industry? Or does it contend, as suggested by the phrase, and rally political and social opposition to the industry, that he was hoping to spark political and social movement to change the health insurance industry? Be clear. Are you saying Luigi Mangione is a danger to future people because he himself is going to go kill other people? Or are you saying that he's a future danger because he's going to incite violence by other people and that was his intent? Either way, you need to articulate which one of those two you're going with. Was Mangione himself the one that was going to be a danger? Or is it people acting on his behalf and that was his intent? And articulate which one it is so that we can properly argue why you're wrong about that case. But if we don't even know which way you're going with it, is it that Luigi was a danger, or is it his intent was to get the public to be a danger? Tell us which way to go. If the government intends to prove that Mr. Mangione intended to kill other people in the health, I'm adding the word people a lot. If the government intends to prove Mr. Mangione intended to kill others in the healthcare industry, who were those intended victims and what proof is there of each such intent? So in other words, if you're going that route, tell us who was next on his list. Show us where Mr. Mangione had some kind of list showing who he was going to target and who was next on the list. Oh, you don't have that? Then how do you argue he was going to kill somebody else? You don't have that list. And I would argue they don't have that list. It doesn't exist. All right. If Mr. Mangione only intended to rally political and social opposition, this is the other argument. If instead it's not somebody specific and Mangione was just trying to get political or social opposition to the healthcare industry in a whole, in what way does that make him a future danger anyway? Even if Luigi Mangione intended for society to get angry and do something, how does that make Luigi Mangione a danger? How is what happens in the public outcry specifically a danger by Luigi Mangione, and Luigi Mangione needs to be put to death because he's a danger? Explain that to us and put it in writing so we can be prepared to fight that. As for the allegations that Mr. Mangione attempted to evade law enforcement and flee New York City carrying a privately manufactured firearm and silencer, what relevance does that have to proving future dangerousness? And I agree. When I read that whole sentence, and it's like he was going to be a future danger to other people, and he had a firearm and he left the state. How the fuck does leaving the state and having a firearm have anything to do with? I mean, that's what they're arguing. How does that have anything to do with he was a future danger to other people? I guess because you said he still had a gun on him and he still could have done something, but it doesn't show intent to go kill other people. So that's what they're trying to argue. Does the government contend that any alleged murderer who flees the scene of a crime with the murder weapon presents a future danger that warrants imposition of the death penalty? So again, if any other person in this country stabs someone, shoots somebody, and then flees the murder scene with the weapon, does that mean that they are now, because they fled with the weapon, obviously going to go kill other people because they kept the weapon and they fled the scene? They must be willing to kill other people. If that was the case, then why aren't we seeking the death penalty against every single one of those MFers? But you don't. So why in this case does it matter to you that Luigi Mangione still had the gun on him when lots of people commit murder and flee the scene with the murder weapon? That's kind of a natural thing to do. It doesn't mean they intend to go kill somebody else. Why in Luigi Mangione's case does it mean he intended to kill somebody else? Make that make sense. It doesn't make sense to me. They can't make it make sense. He knows it can't be made sense. So that's why he's asking him, show me exactly how this is different than any other murder who they will leave with the murder weapon. How the fuck does that have anything to do with anything about future intent? In that regard, it is worth noting that Mr. Mangione was apprehended in a restaurant in Altoona, Pennsylvania, without incident, not exactly indicative of someone who presents a future danger to others. Mr. Mangione did not resist arrest. He did not fight them. He complied with everything that they said. He was a danger to no one, and he was eating a fucking hash brown in Altoona, Pennsylvania McDonald's. That's where he was. Mr. Dangerous Mangione was sitting there eating a hash brown in McDonald's. He wasn't plotting the death of somebody else. He wasn't doing something that was harming the public. He wasn't threatening people. He was eating a hash brown, and there was no intent of danger and no resistance of arrest. So how is he this dangerous criminal who is out there going to kill other people? And we're almost done. Requiring production of an informal outline within 90, or informational, not informal, requiring production of an informational outline within 90 days would in no way be burdensome or prejudicial to the government. In other words, this is not a big request we're asking. You've already had 10 months. You can spend another 3 months putting it together. We'll give you 3 months, put it together and fucking put it in writing. You've had enough time already. Presumably, sorry, I'm dropping all the F-bombs. I'm a little hot as I finish this document. Presumably, it already has the information necessary for such an outline in its possession because due process requires that such information be presented to a grand jury. Let me explain that. A grand jury does not actually decide whether a person is guilty or not. A grand jury is convened before trial begins, where people are asked, does the government have enough evidence to proceed to trial? It's not a we think this person is guilty or not. It's, is there enough evidence that we're not wasting taxpayers' money to go to trial? A grand jury was convened. The government showed the grand jury, with nobody on the defense team present, that this is why we think we have enough evidence to go to trial, and a grand jury agreed. But by the way, part of the process of that is they have to present to the grand jury why the death penalty is appropriate in this case. So they already had enough information to talk to a grand jury about why death was on the line. So why not tell us why death is on the line in detail? Moreover, the memorandum the government submitted to the Capital Case Committee, in accordance with the Justice Manual's procedures, presumably included the information sought, because the Justice Department procedures require that such memorandum include an analysis of the applicable statutory aggravating factors and a discussion of the victim impact evidence. What does that mean? So there is a capital case committee that reviews potential death penalty cases to see if it's worthy of going to. So that committee already has seen what the state intends to prove on why it should be a capital murder case. They've seen it. The grand jury has seen it. Why the F can't the defense see it? If you've got such compelling information that you convince the capital case committee that it was worthy of death, and you convince the grand jury that it was worthy of death, how about letting us in on the secret? How about telling us what it is you showed them that makes this such an important factor that he deserves death and not the 300 and something other people who killed somebody in New York last year? It is true that in some cases, including the last one tried, and now this last one, I think I'm going to skip for the sake of time. All this basically says in this whole big long language is basically that there was one other case in which they didn't give the defense a whole lot of time, and it basically had to do because of COVID. Because of the COVID timing, things were accelerated a little bit. And even in that case, the court said, hey, this was not the way to have done it. It was done out of order. So in other words, they're saying, I know that some stupid bastard on the prosecution is going to be like, well, we have done this on this time. This is not unprecedented. Yeah, under COVID, you did it. And even then, the court said that was in a rush and you shouldn't have done it that way. So again, in the sake of getting this thing done, because it's not great reading, we're just going to give you the summary on that. Now, for the foregoing reasons, this is the conclusion and the ultimate thing that we're going to end on today. The argument from Avi Moskowitz is basically do this in 90 days and let's go. For the foregoing reasons, and pursuant to the 5th, 6th, and 8th Amendments of the United States Constitution and the Federal Death Penalty Act, the FDPA, the defendant requests that this court grant the motion for an informative outline of the aggravating factors as described above and get it done in 90 days. So, sorry that took so long. It's not super interesting. It's a little dry, but for those of you who are not up on the case, there's some good primer there for you to get kind of boned up on it. I know a lot of you have been waiting for me to talk about Luigi Mangione and this particular document. I've even had a person that got upset with me and like, I'm not going to listen to your channel anymore if you're not going to talk about Luigi Mangione. There's a document out there and you're not talking about it. It has been addressed, and it has been addressed in a long form. Thank you for listening. Hope you come back, that person who decided to take a break from my channel. For the rest of you, hope you'll stay interested in Luigi Mangione. This case is going to be, I think, a landmark case in this country when it's all said and done. This is going to essentially be, in my opinion, the United States healthcare system on trial. But how they do that is going to be tricky because that's not something that courts should do. They'll be arguing, Luigi Mangione's on trial for murder of Brian Thompson. We're not putting the healthcare system on trial, and yet that's where this is going. And I think that you need to be paying attention to the much, much bigger picture here. Thanks, everybody. Have a good day.